with relation to intellectual property. Now, here, what is an intellectual property? When we talk about property, property is something which we discuss that we own it is a property. When we talk about intellectual property, here the intellectual property is something where it is developed using human intelligence. It is developed by using technology. It is developed by using some new inventions, some new ideas. This is what an intellectual property is. Now, it can be related to all kind of new inventions. It can be related to designs. It can be related to any kind of artwork or literary work. It is all intellectual property. Why is intellectual property very important? As we talk about a property, once we own a property, we have some rights on the property and we protect our property. Same in case of intellectual property. As intellectual property, we have spent our time and we have created a new invention in this one to get a new market space in. So once we create any intellectual property, the most important aspect of an intellectual property is to protect that intellectual property. Here, once we protect the intellectual property, it is called as intellectual property rights. So we enjoy some rights once we own an intellectual property. As when we compare it to a property, a regular property, once we register a regular property, we have an ownership rights with the regular property so that no unauthorized person can trespass into a property or can misuse the property. Same lies with intellectual property. Once we register an intellectual property, when the IP is protected, it comes under intellectual property rights and we enjoy some rights over there so that no infringement happens in intellectual property. Now, once we talk about intellectual property, basically intellectual property in India is divided into 4 aspects. One is copyright, second is patent, third is trademark, fourth is trade secret. These are the 4 major aspects of intellectual property which we'll be covering in India. How intellectual property started in India and how it will be helping the new entrepreneurs coming and how it will be helping the new techies coming, we will be going through in this particular session. The first aspect when we talk about is copyright. So copyright is basically some book writer, some musician, some painter, some script writer. Once they create their work and it is protected under copyrights. But in case of technology, once we talk about technology, all the softwares which we produce, all the new softwares comes under copyright in Indian laws. Whereas in US laws, it comes under patents, but in India, it comes under software, it's under copyrights. So all the coders, if you want to protect your coding, that comes under copyrights. And apart from this one, maybe most of you guys have written any kind of journals and articles. So your inventions and your thought process of journals and articles also comes under copyright law. So this is an overview about copyright law. The next very important aspect is patent. Here, when we talk about patent, we talk about the new invention. And as in the present industry, tech savvy industry, we have new inventions every now and then. We create new technologies, we implement new works, we ease out the work. So whatever new technology has been created, it should be protected under patent law. So how patent law started, when patent law started, giving you an overview of patents in India. Patent law was initially started in 1911 by British India. The main aspect for patent law for British India was to keep the prices higher and so that the local players can't compete them in the as far as it is protected under the patents law, and they can charge huge prices on that one. Later on, after independence, we adopted the patent law in 1970. And our patent law is category basically divided into two aspects, patent and off patents. So once we talk about in a patent, whatever new inventions, technologies we implement, that comes under patents. Once we register a patent, we get a life of 20 years, and for 20 years you own that one. You can commercially use that one, you can sell that one, and you can lend that one. After 20 years it goes as off patent. Starting days, if we talk about how patent created a big impact in the global market, is everybody knows that light bulb was invented by Thomas Alva Edison, and it was a very famous patent. Nowadays, if we talk about patents in mobile phone industry, Samsung and iPhone are the two very big players in this industry, and iPhone has maximum patents in mobile industry. When we talk about other technology based industries, is the new coming technology, which is 5G. Most of the patents are owned by Huawei in 5G technologies. So what these guys do is they research on the new technology, and once a new technology is developed, immediately they patent that technology. And once they patent that technology, they can use it commercially, and they have their ownership rights on that one, and no other person without their approval can use that technology. If they need to use that technology, they need to commercially own that one, or they need to take it on hire from the patentee. This is about the patent. The next aspect is trademark. What trademark does is it gives you a image in the market. It gives you a resemblance in the market. It gives you a eye-catching name in the market. Like if you see trademarks, like if you see some trademarks like Airtel, Idea, Vodafone, Indian telecom trademarks, just you see their logo, they are all trademarks. So once we see the logo, it has been protected under trademark. You see an M logo with a particular font, immediately you'll recall it as a McDonald's. You see a right, without naming anything, if you see a right, you will find it is a Nike logo. Same applies with Google, and same applies with any of the new entrepreneur who is coming up. If any of the person who wants to start a new industry, or who wants to do a new business, or who wants to be an entrepreneur, they the first thing they should do is to avoid any kind of infringement. They need to go for a trademark of their name, of their logo, of their design, and of their color, so that in future, if you are looking for a larger scale, once your growth is very high, there should not be any issues of copying of the trademark. So here trademarks plays a very crucial role once you go for big. The next aspect is industrial design. See, once we talk about an industrial design, in particularly every product, there is a uniqueness of its design, which is called as industrial design. Like if you see a image over there in the PPT, we have an electrical guitar. It has a unique industrial design. It could be a two-dimensional feature, or a three-dimensional feature, or a multi-dimensional feature using multiple colors, multiple lines, multiple strings. These all comes under industrial design. So what industrial design gives you is, once you have created that design, it safeguards others from misusing that design. So this comes under industrial design. Next aspect is geographical indication. That is called as, in short form, it is called as GI tag. Well, for a technology industry, it is not that much useful, but it is a part of intellectual property. It gives a local indication. Like once we talk about this Shimla Mirchi, it's a very famous name. It is associated with that particular city, Shimla, as it is called as Shimla Mirchi. We have an GIS tag for our famous Hyderabadi Halim in Hyderabad, which is owned by Pista House. Unfortunately, Hyderabadi biryani doesn't have any kind of GIS tag. The reason behind that one is we couldn't find the source of Hyderabadi biryani. Same, we have multiple GIS tags for most of the food and consumable items. Even in case of liquor industry, we have huge GIS tags. And in case of fragrance industry, we have huge GIS tags. And if you are talking about the watches, then we have got the GIS tag of Swiss watches, very famous globally. So here, GI tags, that is called as geographical indications, will play a good role to recognize your product. The next aspect is trade secret. What trade secret does is, if you have created a unique product of yours and you don't want to disclose the product in the market for any kind of unfair practice or violation of intellectual properties, you don't want to disclose your uniqueness of the product. So here you apply for a trade secrets. Maybe you are seeing an example in the PPTs of KFC, Pepsi, and Coca-Cola. But I just want to share you this information that these companies have never applied for trade secret. The reason behind is, once you apply for a trade secret, after the cooling period, you need to disclose that trade secret. And these companies have never applied for trade secret, but most of the companies do apply for a trade secret. What rights you get in the trade secret is, as you have applied in the trade secret, nobody else can copy your recipe or the uniqueness of your product. And it stops the infringement and violation of trade secrets. Next, what we talk about is safeguarding the next $1 million ideas. So maybe I'm speaking to all technotracks, all future maybe entrepreneurs, maybe the next I could be it could be a new Jeff Bezos over here, somebody like Elon Musk. So what they did is, first they had an idea, they implemented that idea, they protected that idea, and they commercially used that idea, and they sold it to the world. So here, all the new engineers coming over here, once you are creating any of your project or you're working on any of your idea, the most important aspect is your idea should not be copied by others. Your idea is totally your idea and it should be used by you only. And you should get the commercial benefits of your product which you have developed, and your research or invention you have done. You should get the benefits of that, or else it will be somebody else baking the cake and somebody else enjoying the cherry. So if you are baking your cake, you should enjoy the bite of the cake. So what it does over here is, whenever you develop a new product, whenever you develop a new invention, in this age of technology, we are seeing new inventions every now and then. Maybe, if I am not wrong, every fortnight we have a new invention. Every other day we are seeing a new invention. In past 20 years, if we see how rapid the technology is growing, every other day we are getting a new models in upgraded technologies, new softwares, new hardwares, which could meet the market standards. Now, if you are the one who has great idea and you have invented and you have done something very good, and in that one, and you have developed a product, or if you have invented something new, the most important thing is you should do is you should protect that invention. How you protect that invention is, you apply for a patent of that invention. Once you get the patent of that invention, it is, you get a life to your product, that nobody else can copy your product without your permission. Nobody else can misuse your product without your permission, and nobody else can do an infringement of your product or make any kind of inferior quality of your product. So here the licensing aspect will help you out. What it also does is, if you have developed a new product or you have done a new invention, and now you are not in the scale that you could penetrate that product in the market due to huge finances involved in that one, you can sell your patented idea to any of the multinational companies at a very huge cost, or you can do them as a joint venture, or you can become an OEM manufacturer for them. These are all aspects which will be covered once you have protected your product. or the invention or maybe services. So the next thing what I talk about is in India, in patent laws, we have before India became a member of WTO, we had two kinds of patent laws. Uh, Primary, it was product based, and next it was process based. So what it does is product based patent laws, everybody knows you have developed a new product, you have invented a new product, you have invented a new technology, that is all product based. We have one more, that is process based. So in process based, once you are developed a process, you can sell that process, and with the help of that process, another player can develop the product. Maybe you can, in an easier name, you can say it as a generic product. It is all using your parameters, your aspects. We developed a process based patent. But after India becoming a member of WTO has given a 5 years time to develop countries and 10 years time to underdeveloping countries and 15 years time to lease, 11 years time to lease developing countries, to convert them from process based to product based. What it helped in India is, as you might be knowing, India is a hub for pharmaceutical industries. We are the largest druggist manufacturer in it around the globe, and we are the largest exporter for the druggist. Due to this process patent, we could develop the low cost drugs and we could export it throughout the globe. And after 10 years, that was, India became member of WTO in 1994, and 10 years was completed in 2004. In 2005, we have come up with an amendment of patent laws, where we have come up with a price barrier. To meet the process based patents, what we have done is, in pharmaceutical industry, exclusive in drug manufacturing, we have come with a price barrier, so that this price barriers could help the players who manufacture the generic products. And other than this one, we can see a very famous name in Hyderabad. It is the company called as iLabs, owned by Vishweshwar Reddy Garu. So what that company does is, that company mostly focuses on patents. They have huge patents in their names. In multiple industries, they have patents. They have developed the products and they have done the patents, and they are commercially selling the products and earning the royalties. Another company which I can talk about is United Technologies. You'll be shocked to know that United Technologies have got nearly about 25,858 patents in many aspects, including air conditioner, joints. They manufacture from pin to plane, everything, and they do a patent of that. Once they have a patent, they sell the patent to other players. So this is also a very famous company. Then we have one more very big company called Qualcomm. Qualcomm has all technology based patents. You might be familiar with the CDMA technology. CDMA technology was owned by Qualcomm, and anybody using a CDMA technology, any manufacturer manufacturing a phone using CDMA technology, had to pay a particular amount to Qualcomm to use that technology. As presently, 90% of the smartphone industry, low cost or medium range smartphone industries, are run on Android software. Again, Android is a patent of Google. Whoever use that one, they need to pay for using that software to Google. So this is all game of patent. The next, we talk about how to secure patents in India. What are the methods of securing patent in India? How important patent is there? What is the procedure of patents? How to register a patent, and how to stop infringement of patents, and how to challenge the patents if there is a violation. The first and primary thing is, if you are looking for a registration of patent or trademark or copyright or design or GIS, this all comes under one bucket, that is called as ipindia.org, which is owned by the Government of India under Department of Ministry of Commerce and Industries. Here we have got different portfolios where you can enter into the particular portfolio of patent, design, trademark, GIS tax, and in particular class you can register your product. You can check that is there any particular product already registered in this class, or you are the first mover in this class. If it is already registered, how unique is your product from that product? How unique is your invention from that invention? This is a very important aspect. You need to study thoroughly with the what are the available patented products or available copyright softwares which are available presently in the market. Next, once you develop that one, once you have got the patentee rights, then you have got the complete power on that one. If still there is a violation, then in India we have got a primary tribunal. That tribunal means special courts. That special courts are called intellectual property appellate tribunal, which is there in every major city of India. If you are still your dispute is not resolved, then you can move it to High Court and then Supreme Court. Unfortunately, in India, we don't have arbitration process in IP laws, where in other countries still we have an arbitration process in IP laws. Maybe in future we can see an arbitration process in IP laws which can help both of them get advantage of arbitration process. So these are the briefs about the patent laws, the copyright laws, the trademark laws, the industrial designs. So now what I suggest with all the participants over here is, maybe most of you guys who are in the final year of engineering or probably doing MTech or probably as a research scholar, whatever project research work you are doing, and if you are inventing a new product, or if you are developing a new software, or if you are developing a new technology, the first thing you do is, once it is in developing stage and once everything is on the paper, apply for a patent. Before any other exploit your product, what happens is, now you think, why I need a patent? Why should I go for this hectic work of legal battle applying for a patent? I'll develop a product and sell it into the market. Now, as a startup, you can think that, yes, I can develop a product and sell in the market. Think about your product growing in a larger scale. Once you are in a particular larger scale build, then the problem occurs. Then these persons, you have done your research on this one, you have spent some years on that one, you have spent some huge money on that one, and you have developed a new product design technology. The other persons enters into that one, that they steal your idea, they steal your work, and what they do is they simply copy your invention and sell it at an inferior cost, at a very less cost. So here you are getting a dual losses. The primary loss you will be getting is whatever market share you had. Imagine you had a market share of 100 every day. A Y person enters, copies your patent, as you have not applied for a patent, copies it, copies your invention, copies your technology, and sell it at a lesser cost. And maybe if you could dent your only 10 customers, and imagine that 100 such players enters into the market, you are gone out of the market, because they'll be selling that product at a lower cost. And the other thing which could affect is the inferior quality. They'll be developing the same product at inferior quality, and it will be creating a big problem to you, because the purchaser or the one who is using this technology will be in an impression that you are selling it. So patent laws always helps you give a double protection. The primary protection is you have a right on the product that nobody else can use it without your permission. And second is nobody can sell it in the market. And in case of codes, the software developers we have, they develop a code. Unfortunately, in India, we don't have patents on software, but we have some protections on softwares, that is in copyrights. So whenever you develop any new software, whenever you develop any new code, go for a copyright protection immediately. so that no infringement happens with your software. So this is a little bit introduction on the IP laws, IP and IP protections. Now, if anybody have any kind of questions, they can put forward the questions. I'll be very enthusiastic to answer your questions. Any questions, please?
No, sir.
Any questions which you have got through email or SMS?
Regarding what, sir?
Regarding the intellectual property, you have got any
Like,
queries, or anybody has any?
We have got only copyright claims from YouTube. Like, if we upload any kind of video, we get like this copyright claim.
So what happens with the, once you apply for it in YouTube have this clear instructions mentioned that you can use it with their permission, but you can't use it commercially. If you are using for the purpose of information and for the knowledge on and for public awareness, you can use it. That flexibility you have, and
Okay.
you can't put forward the complete clip. And if you
Okay.
are using any short clip of that one, you need to give that reference that you are using it for the purpose of knowledge and for the purpose of social awareness, not for the purpose of commercial exploitation.
Okay.
Because you don't own that creative work. It is created by somebody else. They are the owners of that creative work. Now, as you have discussed about YouTube, now what happens is, if in case you have not applied for any intellectual property right reservation, like you have not applied for copyright and you are not applied for patent laws also, but you are a familiar name in the market. For say, now there is a trending going on Insta Reels and on YouTube,
Yes,
that is
yes,
Kacha Badam. Kacha
yes.
Badam.
Yeah.
Kacha Badam is owned by a particular person. A particular person has developed that song with a
Yes.
particular tune.
Yes.
And tomorrow, maybe after 3 months, he applies for copyright, because everybody knows that he was the one who has developed that Kacha Badam. Immediately he can get copyright protection on that one, and all the others who are using, in case if it is not copyright protected also, futurely he can put a claim on the ones who are using that particular tone or particular lyricist what they have done. So this is first mover advantage in copyrights and patent laws also.
Yes, sir.
It applies in other aspects also, but exclusive in copyrights, we have that first mover advantage, as we have that documented evidences that this was first written, or this was first prepared about, this was first sung by that particular person. Same applies with the writers, that if they have published a book, maybe they have not claimed for a copyright protection, even though without the permission, if you use that, yeah, tomorrow that person can claim whatever the losses you have. We have a classic example of Chetan Bhagat.
Yes.
He wrote a book. And on the inspired by that book, the
Movie
movie
was.
was there, Three Idiots. Okay, but the producers of movie have never given the credit to Chetan Bhagat that they have been inspired from the novel of Chetan Bhagat.
Okay.
What Chetan Bhagat did is he moved a legal battle against the producers of that movie, and at last they had to give him the credit that this was inspired by the novel of Chetan Bhagat. So this applies with all the new journals. If you are writing any kind of journals, and if you have published in a journal, or you have published any article, maybe in nowadays what happens is we have a lot of issue with plagiarisms. We have a lot of issue whenever somebody gives you any assignment of writing any kind of journals or any kind of articles. What you do is you directly use it from Google, you use it from somebody else, and you put your name over there.
Yeah.
that person can any damn day
Hmm.
put you in the legal battle. So without the person's approval, you can't use it, or you can't give your name to that one. You can at least mention that one, this has been inspired by, or I have taken a briefing from this particular journals or this particular articles, and I have developed or have revised this article. Without mentioning the original author or original writer's name, you can't directly put your name in this one, or else in future you will be struggling in a big legal battle, and that legal battle could be $1 million legal battle if it is somewhere, if it is copied from any international journal. Most of the students, what they do is they simply copy any IEEE journal,
Yes. Yes.
any
Yes.
Scopus journal, and they
Yes.
put their names.
Yes.
If that is documented and that is published in some other book that you have copied from that particular already existing journal, then tomorrow that person can anytime sue you.
Yes, sir.
So this is the very important thing that students should know before blindly copying any journals or any articles.
Yes, sir. Yes, sir. Okay, sir.
So,
And
any other
sir,
questions?
I know
Yeah.
today many of them have not attended, but
Okay.
I have recorded this video and I'm going to upload in the YouTube in our
Sure. Sure. No
Shagat
right.
College.
No copyright. No copyright protection from my side. So I give you the complete rights that it is copyright free. You can put
Thank
it.
you, sir.
You can use it in a commercial purpose also,
Yes.
because this is an
No,
informative
no.
based videos.
Yes, because it is informational, we'll tell students to watch it in the YouTube, sir, in our channel.
Yes. And please do let me know once it is uploaded on the YouTube also.
Yes, sir,
And
sure, sir.
whatever the students who are doing for the projects, if we are see any potential in any of the students who are doing very good project, very good
Okay.
invention, or they have very good ideas which they are in developing stages, just back that students to apply for a patent protection so
Yes,
that
sir.
they can commercially use whatever they have developed.
Okay, sir. Okay, sir.
So for all the BTech students, MTech students, and even the research scholars,
Yes.
whatever they do,
Mm.
it is always recommended that they go for a patent protection.
Yes, sir. Okay, sir. Thank you so much, sir, for taking your time and
Thank you for the, it
giving us
was a
info.
great session and you are a great host. Thank you very much.
Thank you so much, sir. Have a good day, sir.
So can I just leave the session?
Yes, sir. Sure.
Yeah. Thank you.
Thank you, sir.